Hello, my name is Randall Borden. I'm an attorney. I practice in both Virginia and Maryland, and I put on these series of videos in hopes that educate you on how family law works. So I just want to remind you if you need any consultation, my office is in Fairfax City, Virginia, which is the Northern Virginia area, a suburb of Washington, D.C. So please give me a call, email me, or text me, and I can help you out. This presentation is on a new case called Stewart versus Campbell. That was decided by the Virginia Court of Appeals this year. It is a very complicated custody case. It was heavily litigated in multiple states. It went on for many years and was quite involved. The portion that I want to talk about today, though, is just a small portion which deals with custody, and in particular, one of the factors in the Virginia Code 20-124.3. So just to review that code section, Virginia Code 20-124.3 lists the factors that a court must consider when it's awarding custody or visitation, either permanently or in a pendente lite or temporary order. And it details that the court shall consider each of these factors one by one and evaluate it as far as the best interest of the child. And that if the judge doesn't do that, then it can be reversed on appeal. It's reversible error. In this particular case, the mother appealed, saying that the court did not consider sufficiently one of these factors, and that would be factor number 9. That's the one that deals with violence. And in the mother's case, she asserted that certain protective orders that she obtained in another state were not sufficiently considered by the court, and that therefore the court had made a reversible error by not considering or by not giving a sufficient weight to this evidence of what she considered to be domestic abuse. The part to get out of this case, however, is degree to which the appeals court analyzed what the judge did and how the judge gave weight to each of the factors. So it says that the trial court below the Court of Appeals does not have to quantify or elaborate exactly what weight or consideration that it is given to each of the factors. In other words, it is enough that the trial court judge does consider each of the factors, and then it's up to the trial court judge to put the weight of the evidence on each of those factors when they make the findings. Another lesson of this is that on appeal, the appeals court will not substitute its judgment for the judgment of the trial court. So it says we do not retry the facts or substitute the view of the appeals court in place of the view of the judge at the trial court. It is very important that you do put on a good and complete case when you're in a custody or a visitation battle. The way that lays out in a divorce case, it really starts at the beginning. At the beginning, you'll serve discovery. That's normally a list of questions that the other side has to answer under oath and a demand for documents that the other side has to provide. Generally, the other party's attorney will do the same right back at you, so you will have to answer the questions under oath. You will have to provide the documents that they request. And it's very standard in these questions and document demands to list out these factors, the factors in Virginia Code 20-124.3, and ask the question, which one of these factors applies? And if it does apply, how does it apply? You really have to spend some time when you're answering the questions and when you're gathering the documents, because this is when you present that. So in other words, first you have to answer it. You have to provide the answers and the documents to the other side in your responses to discovery, and then you can present that to the court. And again, the court has to consider each of the factors. So you want to make sure that whatever evidence you have, whatever documents, testimony, witnesses that would count or would be applicable to one of those factors, you want to make sure that you bring that out, first in your answers, in your responses to the discovery, and then second in the testimony or the presentation of evidence in court. So if you have a witness who might testify that the parents don't get along, which is one of the factors, you want to make sure that you identify that witness in your discovery responses, and then consider having that witness in the court at the trial to testify live at the trial. Everything that your lawyer is doing in a custody or a visitation case is focused on the trial, obviously, but then having something on each one of these factors. And of course, the more that you have, the stronger your case. It's not necessarily quantity, but if the factor applies to you or to your children, you definitely want to have that brought out at trial, obviously, because then the trial court will analyze or consider each of these factors in Virginia Code 20-124.3, and then will make a finding as to, does the factor apply? And if it does apply, how does it apply? Sometimes the judge will say that favors the mother or that favors the father. And then you have a record of what the court considered, how they ruled, and obviously what their conclusion was, who was awarded custody or visitation. As far as when your lawyer is bugging you to please get your discovery done, to provide the documents, to make sure that everything is complete, make sure that it's updated. So you want to update it right before trial so you have the most recent information for the judge to consider. You help out your lawyer. This is what everyone is, both sides, is working towards. Obviously the trial, but to have the items, have the testimony, have your testimony that will go to these factors, so that when the judge does consider each factor, and assume that the other side is going to be doing the same thing, so that when the judge does consider each of these factors, that they rule correctly, which hopefully is ruling for you. So overall, this case is very long, very complicated. The Court of Appeals did a great job in laying out the facts and parsing everything out. And so again, that shows you how complicated a situation can be just for custody and visitation. But again, even be that as it may, it's still critical that you provide that information to your attorney, and that it does get into the discovery, and then from there you want to make sure that you're able to present that to the judge. That is what it's all working towards in a custody or visitation battle. So when you get requests to go get the school records, the doctor's records, or bank statements, or whatever, this is what your lawyer is doing. Is laying it out in these factors, and to make sure that they have enough or sufficient or strong enough for each one of these factors so that you would prevail in the case. So that's really the message of this, is to show how it works in the court, despite all of this other litigation going on all around it. This is what it boils down to, at least for custody. I hope that was helpful. I hope that emphasized the importance of working with your lawyer and providing the discovery and the information they want. So again, my name is Randall Borden. I put on these videos, hopefully help educate you in how family law cases work. My office is in Fairfax City, Virginia. I practice both in Maryland and Virginia. So again, if I can help you out, please contact me. If you like this video, if you want me to do more of them, then subscribe, click the like button, click the subscribe, and I'll keep making more of these on the topics that you all want. Thank you very much.